Hello everybody. Professor Adam, thank you very much for the invitation to be here today. To be honest, when we undertook this research together with my technical colleague, which is Professor Joshua Ellul, I was kind of afraid that we are crazy because we were thinking of trying to apply blockchain in the administration of justice. And I'm very happy to see today that we're not crazy, and most importantly, that we're not alone, as I have seen that other colleagues as well have already talked about how these technologies can be included. And actually, many times they mentioned access to justice. And this presentation that I'm going to offer is exactly about access to justice. Now, what motivated us to undertake this research is the first thing that I will try to explain. Then I will give you some backgrounds about the service of judicial documents within the EU, which is a very important part of access to justice. And then I will try to showcase what we're trying to build. Although a disclaimer, remember that I am an academic from law, which means that my technical knowledge is rather limited. I will try to the best of my capacity to give you a description of what is the idea that we're trying to implement. But if I miss the technical details and I do a bad job at that, please excuse me. It goes without saying that the technical details are going to be available. We're going to publish a paper. So the technical description is going to be much clearer. And in any case, I will also give you the email of Professor Ellul, who is the technical mastermind behind that. And you can go ahead and ask him any technical inquiries. Now, when it comes to the first problem, what motivated us to undertake this research? Before I explain that, a disclaimer. In the spirit of Article 50 of the EU AI Act, which soon will be at the official journal of the EU, all the images included in this slide deck are AI generated. Article 50 imposes an obligation to make that clear from the system. We don't have that yet, but I disclose it in advance myself. For us, it has been an unexpected journey, this research. Why? It has been an unexpected journey. Unfortunately, no dwarves or other magical creatures, but we started this research by discovering that courts in the United States and in other common law countries have accepted service of judicial documents via NFTs. And of course, we got curious, how is that possible? And although I don't want to tire you with the technicalities of the legal part of how this is possible, there is indeed case law that confirms that. For example, there is the LCX case in the United States, several indications on that regard, but in one of them, service via NFTs was accepted, and the same happened in the UK. The Aloya case, always have trouble with that name, is another example where courts have accepted service via NFTs. You might wonder why. The basic problem was the following. These are all typical blockchain hacks in the sense that somebody has been defrauded by somebody else whom they do not know. The only thing that the plaintiffs in these cases knew about their attackers was their blockchain public key, the public key used to defraud them and remove their assets from their own, so to speak, public key. And that was the basic infrastructure that these courts have used in order to allow service. They said, you know something? The only thing you know about your attacker is their public key. Well, send them an NFT with the court documents in that public key, and we will consider that to be a legitimate service. Now, of course, there are several legal issues that surround this problem, but as you can imagine, being an interdisciplinary team that consists of a lawyer with very, very strong attachment to law enforcement and a technologist who is curious to see how the technology can be used, it kind of brought us more into this problematic. Now, the starting point of our inquiry was okay, that happened in the United States and the UK, but what would be the case in the European Union? Is something like that conceivable if it happens before EU courts? And we understood that our research could potentially go down to two different paths. We would either talk about the service of documents, especially when it comes to persons that are unknown attackers, like it happened in the US or the UK, Or we could also think whether we can include blockchain in the process of serving judicial documents to defendants that are known, and they have a known address in the EU. We decided to go down both paths, but today I'm not going to talk about the problem of servicing somebody who is unknown via NFTs. We're working on a follow-up paper on that. Today I will tell you what we discovered when we tried to see whether we can serve electronically utilizing blockchain to persons that have a known identity and address in the EU. Now, some EU law background in order to help you understand what is the context here, what is at stake here, right? Now, I know that many of you have heard for the very first time in your life today the term service of judicial documents, and I don't blame you for that. Of course, it is a very technical, procedural thing in law. But I can tell you that despite the fact that it appears procedural and therefore uninteresting, it is very important. Why? Because it sits at the top of the process of asserting and defending your fundamental rights. You cannot, so to speak, defend your rights if you are not being given a fair chance to appear before a court. In essence, the right of access to justice in reality is a right that serves as the ultimate guarantee of all the other fundamental rights that are awarded to you from the Charter of Rights, of the Fundamental Rights of the EU. And this is not something that I made up from my mind. If you look at Article 47, paragraph 2 of the Charter of the Fundamental Rights, you are entitled to a right of access to justice. And most importantly, the case law of the Court of Justice of the European Union has confirmed what I'm trying to describe to you. The Court of Justice has, in numerous occasions, one of them was the Henderson case, insisted that while the process of service of documents wants to allow the plaintiff, that is, the person that tries to bring a lawsuit, to have quick access to justice, at the same time, it needs to allow the defendant, which is the person that is under attack, to be given a fair chance to defend themselves. What do I mean, a fair chance to defend themselves? They need to be notified in a specific, certain way and within a deadline that would allow them to assert what they are being attacked for, to prepare a defense and appear before court. That is what we're trying to achieve here. That is the process. Now, how do we do that in the EU right now? How do we make sure that if somebody from outside of your member state in the EU tries to bring a lawsuit against you, you're going to be properly prepared to address the situation? Say, for example, that somebody from Germany here wants to sue me in Malta. What is the process that you have to go through in order to make sure that you're going to have access to justice? Well, we have a very traditional system that is regulated by the Service of Documents regulation in the EU, that is Regulation 2020/1784. And in essence, it involves public authorities, both in Germany and in Malta. So if you want to sue me in Malta, you have to first file your documents with the courts here in Germany, then get copies of these documents, translate them, give them to the national authority in Germany that is authorized to do this service. They will take your documents, put them in an envelope, mail them to Malta, to the Maltese authority that has been designated by the Maltese government to receive such documents, and then this authority will try to find me and give me the documents in my hand. Now, it sounds simple, but as you can imagine, this process might take several months, up to 8, or even longer if Greek authorities are involved, right? Which is the country of my origin. It gets even worse there. Now, in that sense, especially in an era where transactions are instantaneous, you can imagine that this is not an absolutely satisfactory system. So we're trying to move from this, which is the traditional paper-based service, to something a little bit more digital. But I have to tell you that during this research we came to a bitter conclusion, that the EU has been left behind. While member states individually have tried to digitize the way that they share documents with the citizens, the EU didn't keep up. Not until this recast regulation of 2020 came out, where the EU tried to digitize the situation a little bit. What are the two major digitization initiatives? First, the EU has finally created a centralized/decentralized electronic system that allows the authorities that I mentioned previously to communicate electronically. So under this regulation, if you from Germany try to sue me in Malta, you can give your documents to the German authority, and the German authority can communicate with the Maltese one using the e-Codex, which is the designated electronic system made by the EU. But still, the communication here is between authorities. The question is, you yourselves, can you use any of the technological means available in your hands to send me the documents that you want to serve me? For that, there is Article 19 of the regulation, which provides for the electronic service of judicial documents. Direct electronic service in the sense that one party can directly send them to the other without any involvement of any authority. It sounds good, but there are limitations. The legislator has allowed, so to speak, a very reluctant electronic direct service. In reality, your chances of serving your documents electronically to somebody outside of your member state really depend on what your member state allows. So if in your national legislation, your member state allows service of documents electronically, then you can also use that to serve somebody outside of your member state. If, on the other hand, your member state does not provide for something like this, then sorry, you cannot serve electronically. Now, you might say, okay, what's the problem? Well, the problem lies with the fact that member states have different attitudes when it comes to allowing service of documents electronically. There is a group of member states that one way or the other allows electronic service, but there are member states, including Malta, unfortunately, where we came from, where no electronic means are available. Funny thing, if you from Germany want to sue me in Malta, it means that you can serve me electronically because Germany allows you to do so. If I know from Malta want to sue you and serve you electronically, I can't, because Malta, unfortunately, does not allow for electronic service. And of course, there is a further problem with the way the regulation has allowed electronic service, because the two available modalities are a little bit limiting. If you want to serve judicial documents electronically in the EU, you have two methods, provided that your member state allows electronic service in general. You can either use a qualified registered electronic delivery service provider. I don't know whether you have heard that term before. I heard about this term the first time when we did this research. Apparently, that is something that was enacted back in 2014 with the eIDAS regulation. But my idea is that it didn't really caught up. And to prove my claim, I will use Germany as an example again. Germany is a member state that only allows electronic service via using qualified electronic registered delivery service providers. The problem is that within Germany itself, there are not many that offer these services. And even those that offer these services do not have a wide user base. So the chances that you and your judicial counterparty are going to be using one of these services are rather minimal. And therefore, your possibility of serving the documents equally limited as well. So, there is a second method, though, that the regulation allows. You can serve by email, provided, nonetheless, that the other party will give you specific consent to using email for this particular dispute, and that they will specify that email address. Now, again, the regulation has left a certain degree of discretion to the member states. The regulation says that if your member state wants, they can impose extra limitations on the service via email. Some of them have done so. Belgium and France, for example, have put a list of further requirements if you want to serve using email. In essence, the extra requirements that Belgium and France have put in place are requirements that want to make sure that the identities of the parties and the process of delivery have actually happened. That you have indeed been the person that initiated the service, the other party was indeed the person that was addressed, and that indeed you consented for this specific dispute and you indeed received the documents. That's the spirit of these extra requirements. So when we came to if blockchain has anything to add in this process, we had to make certain design choices. And first and foremost, no surprise, we decided that we're not going down the qualified registered electronic delivery system, for the reason that it has generally underperformed and that it adds a huge layer of cost and complexity in the process. Our focus was on whether blockchain can somehow enhance the service of judicial documents via email. So in essence, what we are proposing through this research is that the use of blockchain next to email as an infrastructure, it can help quench the reasonable doubts that member states have about the security and integrity of service via email. Now, this is the technical part where I told you that I'll do my best to give you a description of what we're trying to do. In this process, I might not be good at doing so, but let me see whether the visuals can help me a bit. So, in essence, what we're thinking about is a platform that will not require any of the parties to have any strong technical expertise or anything, but most importantly, it will be utilizing email as the main method of communication. On the one hand, we have the person that is responsible for the service, and on the other hand, the addressee, which is the person that is supposed to be receiving the documents, right? And what we are trying to do, first and foremost, is that we want to verify that the person that is supposed to receive service has agreed to that, because that's one of the most basic requirements of the law. And while there are auto-acknowledgement systems in place that can do that, we want to make sure that the addressee has consented to the service via email. To make sure that this has happened, of course, we cannot go and sit next to the addressee and force them to consent, but if they are willing to engage with the system, a log onto the blockchain can be created that they consented. Which means that later on, there is going to be extra assurances of trust that indeed this person consented. Now, when it comes to actually servicing the documents, in the system that we have in mind, the addressee will be in place first and foremost to specify the email address and engage with a specific page that will allow them to both specify the specific email address where they're going to receive the service and confirm once again that they agree to be served in that manner. Again, the system will create a log on the blockchain that the addressee has interacted with that part, and eventually that they have specified the email address and that they have consented to do so. So again, everything logged, so to speak, on a blockchain. By the way, you might ask me, which blockchain? Any blockchain. Right? There is no limitation on that. Ideally, a public permissionless, controlled nonetheless by public institutions like EPSI, or something like that, but it can be any blockchain. For those that can afford Ethereum gas fees, they can also use Ethereum. It's up to them, right? There is no shortage of options out there. So, similarly, every time that the addressee is trying to engage now with the downloading of the documents, logs on the blockchain are going to be created that they engaged with the download, that the download was initiated. There's going to be a hash of the documents that have been downloaded on the blockchain, and eventually that download was completed. Everything again is going to be logged onto a blockchain from the system, so that certainty exists about these issues. And of course, we made specific arrangements also about the possibility of the addressee to refuse the documents. remember what did I tell you in the beginning? You from Germany want to sue me in Malta, and although I coincidentally speak German, it's not to be expected that people in Malta speak German, which means that while you are allowed to file your claim in German, you have to accompany it with a translation when you send it to me in Malta. And if your translation is non-existent or very bad, I have a right to refuse service of documents. So the system also caters for that right to refuse the documents. Why? Because, of course, as you might understand, if the translation either does not exist or it is inaccurate, the defendant has no way of knowing really what the dispute is about and what are they requested to do. Now, did we make any great technological breakthroughs? No, we didn't, and we are fully aware of that. Have we, proved that blockchain is the solution to all problems on this planet? No, we didn't that as well. But what we're trying to do is to at least convince the Maltese government to consider digitizing the service of judicial documents. And the message that we want to impart is that blockchain is not only about speculative assets. It's a technology that started with the basic premise of improving trust in digital environments. And the service of judicial documents is a process that requires a lot of trust. And rightfully so, fundamental rights are at stake. And we do believe that blockchain has lots to offer in that regard. And while our solution currently is limited, because it has to work within the confines of the existing legislation, we do believe that this is a dialogue worth opening, because in a future iteration of this regulation, hopefully, more room for technological innovation might be allowed. And we do believe that blockchain can indeed help with this process. Thank you very much for the invitation.